why not 55 read with 59?
But these are 59.
No, the 59 bhi pad lena.
59 relates to matters incidental or ancillary to any matter enumerated in this part.
So it may not, देखिए जरा सा, my understanding is I may be subject to correction. It may specifically be mentioned there, but it can expand.
बिल्कुल सेपरेट करें।
खान बंदारी साहब शायद बेहतर जवाब दें, शायद या सुनते हैं इनको।
जी सर, बिल्कुल। Thank you very much for.
Thank you. You are a petitioner?
My lord, I am representing PTI. Your lordship.
Are you a petition number?
My lord, notice was issued in all petitions.
Have you filed something?
My lord, I filed two concise statements. CMA 3933.
3933.
And CMA number 8351.
8351. What are the difference between the two?
My lord, the first was filed several months ago. The 8351 was filed yesterday in the light of the observations that have been made on the last date of hearing, the submissions made by counsel. I've tried to address some of the points that have come up during your lordship's observations.
No, first of all, tell me where you stand.
My lord, I am under instructions to support the petitioners, but with some caveats. I am not saying, and I'll just say this and then move on to my submissions. Well, I am not saying that the Parliament cannot per se make any law as far as the practice of the Supreme Court is concerned. It can, but that power is heavily circumscribed by various express and structural limitations within the Constitution. So that's heavily circumscribed. But within those limits, it can. And I'll expand on that. So as my Lord Justice Mansood just said, there are two aspects to the...
First, finish your thing.
My Lord...
Then you come to what we have observed.
My Lord, yes.
You are conceding that the Parliament can, but their powers heavily circumscribed.
Heavily circumscribed.
Now, which particular provisions of this Act are you think the Parliament has exceeded its jurisdiction?
If you could first expound on your initial proposition. As far as the first point, if you could expound on that particular part, that the legislature has the power. Explain that. Then move on to the issue where the restrictions are.
My Lord, absolutely. That's exactly how I will address. And I will address both aspects of the law on this point. First aspect is the practice and procedure aspect. Sections 2, 3, 4, 6, 7. And then there is the appeal. And I'll address them separately. I'll start with the practice and procedure bit first. My Lord, the various articles have been read out before the court many times. My Lord, Article 1, let's start off with where the Parliament draws its legislative power from. There are two sources in the Constitution. One is Article 142, which takes us to the federal legislative list. The second are a set of provisions in the body of the Constitution which confer specific power on the Parliament to make laws on identified specific subjects. These are the two sources. Now, the question before your Lordship and your Ladyship, the question before the court is, as has come out in discussion recently, is whether Article 191 by itself, and I emphasize upon the word, my Lord, by itself, is a source of legislative power. And my submission on that is that it is not. And I'll explain the reasons why I say that. My Lord, your Lordship has already seen the preamble to the preamble itself identifies the source of legislative power that the Parliament has invoked. It has invoked two sections, two articles, Article 175(2) and Article 191(2). My Lord, let's just read both of them very quickly. And then compare their language to Article 142. Article 175, Clause 2 says this: no court shall have any jurisdiction save as is or may be conferred on it by the Constitution or by or under any law. This is similar to, but slightly more specific than 191. 191 says, subject to this constitutional law, the Supreme Court may make rules regulating the practice and procedure of the court. Now your lordship may turn to 142. 142 is cast in different language altogether. It starts off by saying, subject to the constitution, a Majlis-e-Shura parliament shall have exclusive power to make laws with respect to any matter in the federal legislative list. So the legislative power is conferred with respect to identified subjects.
Subject to the
Subject to the constitution, and the appropriate legislature is identified. So that's how, in my humble opinion, you identify whether an article is a source of legislative power. It identifies the subject on which the legislature can enact law, and it identifies the legislature itself. Now, if your lordships go back to 175(2), it simply says, no court shall have any jurisdiction save as is or may be conferred on it by the Constitution or by any law. It doesn't say what is the...
ये मैं आपकी तरफ clarify for me. You are saying Parliament does not have power to legislate except items mentioned in the federal legislative list. Is this what you're saying?
My lord, what is mentioned in the federal legislative
Yes or
list?
no?
Yes. And also on what is mentioned in the body of the Constitution. And I'll just take your
Okay, now
lordship.
I will give you an example. My reading of the fourth schedule, I mean, science is developing, artificial intelligence has evolved. उर्दू में इसको शायद मसनूई ज़हानत कह लें, आउटर स्पेस, खलाई बसीत कह लें शायद, सोशल मीडिया, समाजी राब्ता कह लें, तो इनके मुतालिक पार्लियामान कानून नहीं बना सकती है क्योंकि इन तीनों चीज़ों में से एक का भी जिक्र फेडरल लेजिस्लेटिव लिस्ट में भी नहीं है और आइन की किसी शिक में एक्सप्रेसली या इम्प्लाइडली भी नहीं है. अब आप अटेंड कर लें मेरे सवाल को.
माय लॉर्ड, मेरे ख्याल में बना सकती है.
तो आपने अपने ही सवाल को तोड़ दिया फिर अपने जवाब को.
नो माय लॉर्ड, मैं आपने जो लेजिस्लेटिव लिस्ट में एंट्रीज हैं उनको टू द मैक्सिमम पॉसिबल एक्सटेंट.
मैं आपको मैंने 3 एग्जांपल दे दी ना. इनको किसी तरह से भी वहां नहीं फिट हो रही हैं और ना आइन की किसी और शिक में आ रही हैं ये बातें जो मैंने आपसे जिक्र की हैं. तो फिर पार्लियामान के पास तो इख्तियार नहीं है ना. पाकिस्तान स्पेस प्रोग्राम नहीं शुरू कर सकेगा क्योंकि फेडरल लेजिस्लेटिव लिस्ट में इसका तस्करा नहीं है. या तो आप ये आर्ग्यूमेंट करेंगे कि नहीं सिंध कर सकता है, वफाक नहीं कर सकता है क्योंकि बाकी सारे इख्तियारात फिर सूबों के पास हैं. ये तो आप जवाब दे देना.
मैं दे देता हूँ.
ऐसे ब्रॉड आप अगर पेंट ब्रश स्ट्रोक्स लगाएंगे तो उसके लिए अपनी मुश्किलात भी खड़ी हो जाती हैं.
Let me explain. For example, with respect to space programs, if Pakistan has entered international treaties,
कानून की बात कर रहे हैं. कानून
then there are specific entries which allow Parliament to enact law for implementing international
कौन सा
treaties.
एंट्री है बता दें.
Well, entry 3. Entry 3, external affairs, implementation of treaties. For example,
अब नहीं आते आप इसको सुन तो लीजिए ना. ऐसे ना करें ना. थोड़ी सी हमारी भी कदर कर लें. एंट्री 3 को ट्रीटीज की तो मैंने बात ही नहीं आपसे की. आप सुन ना, आप सुन भी लेना. ट्रीटी की मैंने बात ही नहीं की. मैं तो आपको कह रहा हूँ पाकिस्तान चले ट्रीटी से खिलाफ ही कर रहा है काम. ट्रीटीज में क्यों जोड़ रहे हैं हम? भाई किसी को आउटर स्पेस से प्रोग्राम करना है, इंडिया ने किया, कोई ट्रीटी के जरिए कर रही है. अगर हम कल शुरू करना चाहें तो आपके मुताबिक हम नहीं कर सकते हैं या कर सकते हैं. तो अगर कर सकते हैं तो वो कौन सा पावर पार्लियामान इस्तेमाल करेगा?
माय लॉर्ड, लेजिस्लेटिव एंट्रीज में बहुत सी
बता देना मुझे एक.
फॉर एग्जांपल माय लॉर्ड, जैसे ये अगर इसमें ये न्यूक्लियर एनर्जी का
न्यूक्लियर की बात
आया,
अलग है.
उसके अंदर माय लॉर्ड आपने मकल्लक वर्सेस मेरीलैंड का केस
फिर आप लोग इतने मुतासिर हो गए हैं अमेरिकन. हम आपसे हमारा रिटन आइन है उसकी हम बात कर रहे हैं. उनका आइन अपनी जगह है.
मैं आपकी जजमेंट जो कि आपने
भाई अब जजमेंट को छोड़ दीजिए ना.
सिविल एविएशन अथॉरिटी के केस में दी, उसमें आपने
आप जरा ना तसल्ली से बहस करें ना.
बिल्कुल.
या तो आप ये आर्गुमेंट पेश ना करें. जब आप ये पेश करते हैं ये बहस सामने या एक मफरूज़ा करते हैं कि इट इज़ एज गिवन, तो मैं ये नहीं मानता हूँ। या तो क्या मैं ये वापस लेता हूँ ये बात को, आप कहते हैं कि पार्लियामान सिर्फ वो काम कर सकती है जो 142 फेडरल लेजिस्लेटिव लिस्ट या एक्सप्रेसली या इम्प्लाइडली हो, उसके अलावा कुछ नहीं कर सकती। या तो कहीं मैं इस बात को वापस लेता हूँ। अगर आप इस बात खड़े हुए हैं तो मेरे सवाल का जवाब दीजिए। आप जवाब नहीं देते हैं, आप कहते हैं मैरीलैंड वर्सेस उसमें देख लें, भी उसको कम क्यों देखें?
माय लॉर्ड, मैं स्पेस टेक्नोलॉजी के बारे में तो केस तैयार करके नहीं आया नहीं जी, मैं तो प्रैक्टिस एंड प्रोसीजर पे हूं, उस पे मैं सवाल
उस पे बात करें ना, फिर आप ये ब्रॉड स्ट्रोक्स ना पेंट कीजिए।
स्टार्टिंग पॉइंट तो मैं आपसे कहीं से
आप ब्रॉड स्ट्रोक्स जब पेंट करते हैं अपने लिए मसले खड़े कर देते हैं, तो आप फोकस्ड रहें इसी बात पे।
मैं तो 142 जी
लर्नड काउंसिल यहाँ लर्नड काउंसिल आप
मालिक
आइटम 58 देखेंगे
जी,
आइटम
58
और दूसरा मुझे सिर्फ ये बता दीजिएगा
Part 2 entry 3 तो देखें।
notwithstanding आर्टिकल 191 आपका आर्ग्यूमेंट ये है कि the parliament is bereft of jurisdiction to legislate in the context of any of the fundamental rights or access to justice.
My lord, I have not articulated my argument as yet.
अगर आप ये
मैं तो
अगर आप
सिर्फ
कर लें, आई
setup
थिंक
कर रहा था।
बेहतर होगा अगर आप पहले
आप
अपना
argue as you
argument
want.
करें।
Argue as you want.
Please go back to your
I apologize. You argue as you
Your
want.
lordship should not apologize.
चलिए करिए
My lord, for 2 days I have heard all our
करिए
questions. Let me address those questions.
करिए।
Is what I'm saying. My lord, I will answer your lordship's question also.
अब आप
Let
कर
me
लीजिए ना,
formulate.
हाँ।
My lord, the starting for legislative competence is entry Article 142 or the body of the Constitution. Now, body of the Constitution, for our present purposes, the only article relevant is Article 191. In the legislative list, there is entry 55. Now, these are the two provisions that have to be interpreted and read. Article, as I read, Article 175(2), the expression subject to law, which is used in 191, is used in various other articles also. That by itself does not confer any legislative power or on any identified legislature. Just kindly look at Article 14. Article 14. 1-4.
Of man.
Dignity of man.
Article 14.
It says, the dignity of man and subject to law, the privacy of whom shall be inviolable. The law, the province will make the law or the federation will make the law. In order to determine who can make the law for the purposes of Article 14, you have to go to other provisions of the Constitution. The same is with respect my submission for Article 191 also.
तो ये आर्ग्यूमेंट आप पूरा तो कर लें, तो प्राइवेसी के मुतालिक कौन बना सकता है कानून?
मतलब फेडरेशन भी बना सकती है और प्रोविंस भी बना सकता है, दोनों बना सकते हैं। उनके लिए आपको देखना पड़ेगा कि लेजिस्लेटिव पावर स्प्रेड कैसे है, और दोनों ने बनाए हुए हैं, क्योंकि क्रिमिनल लॉ, पीनल लॉ पे
हो सकता है गलत बनाए हों,
प्रोविंस भी बना सकता है, और प्राइवेसी वगैरह के बारे में फॉर एग्जांपल इलेक्ट्रॉनिक क्राइम्स एक्ट है, फेडरेशन ने भी बनाया हुआ है।
नहीं, पर उसी तरह अगर चलें तो 191 में सब्जेक्ट टू लॉ है, एंड सपोज देयर इज नो, एंड आई थिंक देयर इजंट एनी कॉरेस्पॉन्डिंग एंट्री रिलेटिंग टू प्रैक्टिस एंड प्रोसीजर,
There is no.
So then the word law would become redundant in 191.
No, my lord.
What would happen to that?
That's exactly what I'm saying. I'm trying to proceed step by step. So 191, I read it, my lord, but the mere fact that the expression subject to law is used does not confer any legislative power, just as that it doesn't confer any legislative power under Article 14. What it is, my lord, the power is conferred on the Supreme Court. The power is on the Supreme Court to make rules. Subject to law is a limitation on that. It's a limitation on the power that has been granted to the Supreme Court. My lord, there are two Supreme Court judgments which say that, my lord, your lordship, I've mentioned them in my, in my written submission.
Mr. Bhandari, do you mean that
judgment cite kar
The first
citation?
Mr. Bhandari, do you mean that before making rules there must be some law?
Well, I'm not saying that. There may be.
So subject to law, what does it mean, subject to law?
Well, and a validly enacted law by the appropriate legislature. It could be pre-existing, it could
Without any enactment, rule cannot be made.
no, rules can be made. They can
But
be
subject to law.
My lord, the rule-making power is a standalone independent power on the Supreme Court.
But subject to law.
If there is a law, then the Parliament can make that law within the limits that I will just explain.
You said Parliament can make a law.
Parliament can, but I will just explain what in my humble understanding are the limits on that. I will explain that. But there,
citations there.
Ji, my lord,
Mr. Bhandari, that is subject to constitution and law. So you borrowed this power from the constitution and subsequently you made rules.
yes, my lord.
This is the intent.
This is the intent. This is the intent. My lord, the citation is by Khan versus Border Allotment Committee, PLD 1965, Supreme Court 623, at page 633.
For what proposition?
My lord, this expression, subject to constitution and law, was discussed in detail by Mr. Justice Kekaus in his judgment, and this was then followed in LDA versus Imrana Tivana, 2015 SCMR 1739,
एक दूसरा कौन सा है?
2015 SCMR
अब तो दो यार
1739.
ठीक है, ये phrase
LDA
discussed
versus
हुआ
Imrana
है.
Tivana.
This phrase has been discussed.
This phrase, subject to the constitution and the law,
कैसे किस नतीजे पे पहुंचे?
and they said that it means that the power which is being made subject must be made subject to a law which is derived from some other power in the constitution.
ठीक.
See? So that's my submission, that when it says subject to the law in Article 191, in order to know what law can be made under in this context, you will have to go to other provisions of the Constitution.
रेलेवेंट पेज बता दीजिए उसका कौन सा जजमेंट है?
Well, at 65 Supreme Court 623 at 633.
633 और दूसरे वाले का?
And Imrana Tivana का है जी 2015 SCMR 1739, paras 50 to 53 at 1764, 1765.
लाहौर डेवलपमेंट अथॉरिटी वो टिवाना
इस वाली लॉ की सोर्स पर क्या गो
जी
अहेड
इसकी so this by itself I say, so you go back to 142 and there is no other provision in the body of the constitution dealing with this. So my lord, you go back to 142. 142 takes you to entry 55. So let us see whether any
Entry 55 is only related to the jurisdiction part.
my lord, it will also cover practice and procedure. Just let me explain why.
It is only related to the subject to the constitution.
My lord, what?
ये जो आप अभी बता रहे हैं ना, इसमें तो सब्जेक्ट टू दी
No, my
कॉन्स्टिट्यूशन
lord,
है
it's-
एंड लॉ के ऊपर नहीं है, इसके ऊपर आप जो डेफिनेशन बता रहे हैं
Kekaut साहब ने specifically subject to constitution and law भी discuss किया.
जजमेंट है ना, ये एलडीए का जो जजमेंट है इमरान टिवाना का,
नहीं सर, आप वाला देखिए,
पैराग्राफ
केकाउट साहब की.
52 the only word subject to the constitution.
No, sir. ये जो 65 सुप्रीम कोर्ट है, उसमें दोनों
And
डिस्कस.
it is referring the article 142, उसमें तो शब्द लफ्ज ही शुरू में
वो
इंट्रोडक्टरी
तो
है,
सब्जेक्ट
तो बताया सब्जेक्ट टू कॉन्स्टिट्यूशन.
जी, बट जो 65 सुप्रीम कोर्ट है, उसमें ये उन्होंने सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ दोनों को डिस्कस किया है.
इसका जो 65 का है, कौन सा है पेज?
623 at 633.
जरा इसको पढ़ लें.
65 अगर आप देखें सर,
Yes.
जी, my lord, at 633.
ये भी सब्जेक्ट टू दिस कॉन्स्टिट्यूशन ही है, लॉ नहीं है इसके अंदर.
तो है. जी, आप देख लें.
तो पेज आप बता रहे हैं उसमें तो नहीं मिल रहा है.
आप यहाँ से,
You are referring
पढ़
page
देना.
633.
ये सर मैं नीचे से 11th 12th line from the bottom
पढ़िए.
at 633. The central legislature can legislate with respect to jurisdiction of courts, but the jurisdiction granted by Article 98 is subject only to this constitution and not to this constitution and the law. A reference
तो
to
ये
the
तो
various provisions
then
of
my lord is correct.
आगे देख लेते हैं.
अजी अच्छा.
A reference to the various provisions of the Constitution will show that whenever it uses only the word subject to this Constitution, it does not mean subject to this Constitution and the law. But whenever the intention is that a particular provision should be subject not only to the Constitution, but to a law enacted by virtue of powers granted by the Constitution says so. So, when constitution and the law.
So what? I'm not following.
My lord, what it is
नहीं,
saying is,
वो जो आपकी, don't use your own words, use the words of the
my lord, this
judgment.
is that whenever the intention is that a particular provision should be subject not only to the constitution but to a law enacted by virtue of powers granted by the constitution.
It's not
begs the
enabling, it's
question.
not a power that is giving legislative competence.
Yes, that's what I'm saying, that
You have to go
then
back looking for the competence.
Yes, you have to go to the source of the power in the constitution. And
This
there
is-
the
this
source
is-
of the power has to be in some other provision of the constitution, which takes you to 142, and 142 takes you to
No,
entry
fair enough,
55.
but that's not coming out of this judgment.
Well, that is the only judgment on this that I
No,
could.
but this,
नहीं, ठीक है, आपने मेहनत की, that's good.
My lord, but this is how I read this
Sure,
passage.
sure.
My lord, then let's go to entry
you
55.
say that that law under 191 would stand through 55,
It can only stand through 55.
only through 55.
Only through
Chale.
55. Your
But
lordship has-
एक second ठहर जाइए.
My lord.
Why not 55 read with 59?
But these are,
वो तो ठीक
59,
हो।
No, 59 भी पढ़ लेना.
59 relates to matters incidental or ancillary to any matter enumerated in this part.
So it may not, देखिए जरा सा, my understanding is I may be subject to correction. It may specifically be mentioned there, but it can expand